going to be focusing on some of the major issues that we deal with at ALDF related to criminal law in the U.S. And I'm also going to be talking about a lot of the legislation that we have in place in the U.S. to protect animals in the criminal system. And that is a picture, I know you all can't see me too well, but that is a picture of my beautiful cat, Panther. He is part of my inspiration for doing this type of work. So the Animal Legal Defense Fund, a little bit about us before I dive into the law. We are a national nonprofit organization in the United States. Our main mission, our goal, is to protect the lives and advance the interests of animals, specifically through the legal system. And we have about 40 full-time staff throughout the United States to achieve that goal. We have offices in California and Oregon, where I am based. So that's our team in the Portland, Oregon office. As I mentioned, we work on cases throughout the country that were based here on the west coast of the U.S., and we average about 120 cases in the criminal program every year. So to give you some context about ALDF as a whole, as I mentioned, I'm in the criminal justice program. Our civil litigation team works on really innovative and groundbreaking civil lawsuits, sometimes suing government agencies, for example, when they fail to adequately enforce laws. Our legislative department works on local, state, and federal laws throughout the country on issues like dogs and hot cars, animal abuser registries, and more that I'll go into later. And our animal law program is really unique. They work on getting animal law courses in law schools throughout the country. So I'm going to talk a little bit more about what we do in criminal justice. So we assist prosecutors and law enforcement who are working on animal cruelty cases to achieve the best possible outcomes in those cases. So what does that actually mean on a day-to-day basis? So we help law enforcement and prosecutors at all stages of a criminal animal cruelty case. So that means from the time that a citizen calls us or calls law enforcement to report animal abuse or neglect, to drafting a warrant, to retrieving the animals. We also help with trial preparation for prosecutors, and that's the lawyer who's trying the case for the state government, all the way up through trial and sentencing, if that person is convicted. And also when a case is appealed, we will file an amicus brief or friend of the court brief in support of the state's case. We're also really involved in training law enforcement and prosecutors about many specific issues that are unique to animal cruelty cases. We work as well with our legislative department to strengthen animal cruelty laws that are already on the books, and we lobby for new laws. And finally, we partner with a lot of other national organizations that are not animal specific, but that include prosecutors and law enforcement nationwide for conferences and for other trainings. Because education of these folks who are working on the ground is really a very significant piece of our goal to get better outcomes in these cases, because we and other animal-specific groups, just don't have the resources to be involved in every single animal case that's out there. So I wanted to lay out for all of you a timeline, a basic timeline of how an animal cruelty case works in the U.S. system. It may be similar for you. So first, as I mentioned, we'll get a complaint, or law enforcement will get a complaint. A member of the public will notify them about potential animal abuse or neglect. That officer will then follow up on that complaint. They may find out that it's nothing, not actionable, or they might get a warrant to seize the victim animal. The offender can then be formally charged with animal cruelty by the prosecutor. And even before trial, there's the possibility, and we'll talk about this in a minute in more detail, there's the possibility that the animal can be formally released from the offender's legal ownership and adopted to a new home. If the offender does not reach the agreement with the prosecutor, the case proceeds to trial, and if convicted, will be sentenced accordingly. So today I have a very ambitious agenda, and I've assured your professor that I will not be going over the time. I will try to stick to that. I want to talk to you about some of these really key points between the crime scene and the courtroom. So the legality of seizing an animal with or without a warrant, the possibility of forfeiting that animal from the owner's control, the abuser's control, before conviction, what considerations go into a prosecutor's charging decision in an animal cruelty case, some other strategies for trial, like using expert witnesses and anticipating common defenses. And throughout this discussion, I'll be talking about different trends in animal cruelty laws and other related legislation in the United States. So first, a really basic principle of US criminal law that I believe we share with you in Australia, given our common roots in the British common law system. So the basic principle is that the government cannot search your property or seize your property without a warrant. So we always encourage law enforcement, when in doubt, get a warrant. In the US, this principle is really entrenched in our Constitution and subsequent case law that's been decided by the courts. So the Fourth Amendment to our Constitution says that the people have a right to be secure against unreasonable searches and seizures. And US courts have interpreted this to mean that the government, by default, needs a warrant to search or seize property, unless a certain exception exists. So without a warrant, there must be an exception to the warrant requirement. And procedurally, this will be raised before trial by the defendant who's trying to suppress certain evidence from getting into a case. So the outcome of an illegal seizure by law enforcement results in suppression of that evidence, and that can really make or break a prosecutor's case. So that's very important. So why do we care about all of this in animal cruelty cases specifically? So animals are property, classified as property under US law, and therefore search and seizure law about property matters very much in these cases where police are trying to remove abused or neglected animals from a person's possession, from their home, from their vehicle, and so forth. And sometimes law enforcement just doesn't have enough time to get a warrant, but these animals are in danger and need to be removed. So let's talk about one of these exceptions to the warrant requirement, the emergency aid or exigency exception. So this exception had been historically applied to people in imminent harm, or even to evidence that was in danger of being destroyed. But only a few states in the US have explicitly applied this doctrine to animals. So a few years ago in the state of Oregon, where I am, again on the west coast of the US, this exception came up in a case involving a starving horse. Oregon, the state of Oregon had recognized both the emergency aid exception, where officers have a reasonable belief that a person is suffering from imminent harm, and separately the exigency exception, where probable cause is needed and there is an immediate danger to either a person or property. And under either exception, the government does not have to get a warrant before searching or seizing property if either of these scenarios of immediate danger are present. But the question again, in this case, was whether the court would allow for the seizure of an animal, a horse, under this exception. So in this case, the facts were really extreme. This horse was really on the brink of death, was showing signs of severe emaciation, like protruding ribs, and this officer, who had dealt with hundreds of animal cases before, but had never seized one without a warrant, he determined that this was a medical emergency and that this horse would die if he did not seize her right then and there, on the spot, without taking the time to get a warrant. The sheriff said it would take up to 8 hours to get a warrant in this case, and he had gotten a call of complaint from a neighbor, and he stood on the neighbor's property as he viewed this horse. So the Oregon Supreme Court decides in this case that the exigency exception does apply, but not without some very important caveats. First, animals are still property. They really emphasized that. And the court said that it was strictly under this property paradigm that they found this exception applied. They also emphasized that this exception doesn't automatically apply in every animal case, that here, these were really extreme circumstances and facts regarding this particular horse, and that as warrants continue to become easier to get over time through changes in technology, this exception would become even more rare, potentially. But in this particular case, we were thrilled that this was a great outcome for this particular horse and potentially for other animals in the future. And this horse really went on to live a great life for the last few years of her life in a better place. Another example of the exigency exception, this was a case from California, also on the West Coast. A neighbor of the defendant here called police after hearing a dog crying in pain for hours and reported hearing similar crying at previous times on previous days. The police arrived at this defendant's apartment, knocked on the door, and defendant told them that he didn't own a dog, but the police could actually still hear the dog whimpering from the door. And that fact that the defendant was lying to them, combined with the neighbor's complaints, gave them enough to be able to enter that home at that moment without a warrant for fear of the dog's safety. They actually ended up finding a dog who had been tortured out on the back patio, and also another frozen carcass of a dog in a freezer. So in this case, the defendant argued that the police officers illegally searched his apartment without a warrant, and that the exigency exception does not apply to animals. He actually argued that there are many different innocent reasons for the noises that they heard, but the court just didn't buy it. The court said this was clearly an emergency situation, given the totality of the facts that the officers knew, and that they were lawfully allowed under this exception to take swift action to prevent imminent danger. So to recap, this is an exception that is still used very sparingly in the US, and we always encourage law enforcement to get a warrant whenever possible, but it's really a very important step that even though animals continue to be categorized as property in the US, they're really recognized as more than that by these courts when they say that these animals being in imminent danger calls for immediate action without a warrant. So let's imagine now that a victim animal, like a dog, has been legally seized by law enforcement because they have probable cause to believe that the animal is being abused or neglected. So charges have been filed by a prosecutor, and the defendant owner awaits trial. The owner won't give up the animal. They won't relinquish the animal, and they're still legally the owner. There's a chance that the court will order that owner to give up or forfeit the animal after they are convicted of an animal cruelty crime, but that could take months or years in the US legal system. So, here's the problem. When victim animals are seized from situations of abuse or neglect, in between that time of seizure and the time of trial or the case disposition, what happens to these animals? They're still owned by the defendant, but they're in the physical custody of some other caregiving agency. Here that would be the state government or a shelter or other group that's been designated by the state to provide care, whether that's a local humane society or animal control. So this really creates a host of problems for both the caregiving agency and the animals themselves. So first, there's the animal's well-being to consider. Even at the best shelters, they're usually kept in cages. At crowded shelters, these seized animals are exposed to a host of diseases, and because they were seized from a poor situation, their health is probably already subpar, and now they're being exposed to other illness and disease. There's also their mental and emotional well-being, right? A shelter environment is not usually conducive to rehabilitating already damaged animals. They don't get the socialization that they otherwise would in a new home. And of course, they're anxious from the close quarters with all these other animals, and they're in a strange new environment. So in addition, separate from the animals, for the shelter or whatever the caregiving agency is taking care of these animals, buying that food, paying for veterinary care, these costs of care really add up very, very quickly, especially in cases that involve many different victim animals, like a puppy mill case or dog fighting or hoarding. And a large seizure can drain most of that shelter's resources, both physically and financially. Those animals take up space and resources that they really could be expending on other animals that are coming in at a usual pace. So why are we keeping these animals stuck in cages and shelters like we would process any other evidence in the criminal system? There are really a lot of misconceptions still that animals need to be retained by the government all the way through trial because they're evidence of a crime, of the abuse, of the neglect. But because they are alive, animals' conditions will change over time. And in neglect cases especially, right, we want these animals' conditions to change over time. The caregiving agencies are required by law to give them necessary food, water, and veterinary care. So presumably their conditions should and do change over time. But there's really no benefit to the legal system, to the prosecutor, for these animals to be staying in these conditions all the way until trial. The prosecutor really needs documentation of the animals at the time of seizure. That's what is most important, to get pictures of the animals from every angle and the environment in which they were found. It's absolutely helpful, especially in neglect cases, to have follow-up photos and medical records showing that with basic proper care, these animals have improved, their conditions have improved over time. But that can be obtained after only a shorter period of time, much before trial, or even after the animal has been adopted out into a new home. So there's no need to be keeping that animal in these situations all the way and through trial like we would with other evidence. So forfeiture prior to conviction, we call this pre-conviction forfeiture, that can happen not long after the seizure of the animals. This is a mechanism for getting these animals into a better situation and a new home. So bear with me, this is going to get a little bit technical for a couple minutes, but I promise we'll be moving on to some lighter topics after this section. So once an animal is seized, a party can request a hearing for forfeiture of the animals that would remove the animals from the defendant's ownership and place them legally with another party. That would be the state or a shelter or another organization. So notice has to be given to the defendant and any other relevant parties about this hearing. And at the hearing, again, this is separate and prior to the criminal case, at this civil hearing, the court will make a determination about whether the animal was cruelly treated. And the standard of proof will be lower than what we use in a criminal case. It will not be our beyond a reasonable doubt standard that we use in criminal trials. In this pre-conviction civil hearing, the standard will be lower, more like a preponderance of evidence. And if the court at this hearing finds that the animal has been cruelly treated, then one of two things will occur. In some states in the US, that finding alone by the court will trigger the forfeiture. And in other states, the defendant has to post a bond, an amount of money as set by the court, and if they don't post that bond, then they forfeit the animal. So you guys don't need to be retaining any of these details, but when I teach this course in the US, it's important for students to know kind of the layout of how things happen in Oregon. So here it is. After seizure, in the state of Oregon, the prosecutor or the caregiving agency has to petition. Within 14 days, a hearing takes place. And then within 72 hours of a finding at that hearing that cruelty has occurred, the animal's owner, the abuser, has to put up a bond and a certain amount set by the court or forfeits the animal. So again, this process really helps animals and the caregiving entity because the animals are forfeited, no longer belong to the defendant, they can be adopted out, and these caregiving agencies no longer need to be expending their own costs caring for the animals. They're either paid or the animal is adopted out and they're no longer bearing those costs. So not surprisingly, defendants have challenged this process in the U.S. This was a case out of Oregon. A defendant was charged with first-degree animal neglect toward 12 animals, 11 horses and a donkey, who were really in very bad shape without proper food, water, and veterinary care. The court held a hearing, and the defendant failed to post a bond within that 72 hours we just talked about, and the court ordered forfeiture of the animals. So in this case, later that very same day, a defendant was acquitted on all 12 of the criminal charges. So defendant appeals the forfeiture decision saying, hey, I want my animals back. I was acquitted of the criminal charges. But the higher courts here in Oregon held that these animals no longer belong to the defendant because this pre-conviction forfeiture hearing is separate and distinct from the criminal trial. Essentially, these animals were found to be cruelly treated by that lower standard, and the court upheld the forfeiture. Somewhat similar situation in Illinois, which is in the Midwest United States. 8 horses that were suffering from really bad neglect, malnutrition, and lack of heat. 1 horse was really close to death. And the defendant had prior cruelty related convictions, was charged with 4 felony counts, and the state petitioned for pre-conviction forfeiture. Defendant ends up appealing that, and again, that court in that state finds that this was a separate process, and therefore the animals were rightly forfeited in that case. So again, this is really a very pragmatic solution to a problem that we've dealt with here in the U.S. We're seeing many, many more states adopting pre-conviction forfeiture laws, and it's a really crucial mechanism to prevent kind of a re-victimization of these animals that are taken out of cruel situations. So enough with pre-conviction forfeiture. Let's talk about the charging decision in the U.S. The prosecutor's decision to charge animal abuse, neglect, abandonment. So first question, can charges actually be filed? So in the U.S., animal cruelty is largely prosecuted at the state level. And just a little plug for our compendium of animal protection laws. Each year we compile animal cruelty related laws for every state and territory in the United States. We organize all of those laws according to 15 different categories, such as penalties, forfeiture laws, general cruelty laws related to fighting, seizure, protective orders, and so on. We publish this every year. And you can see those laws by visiting our website at ALDF.org. Also on our website, we have model laws defining abuse and neglect, definitions, forfeiture laws, penalties, and so on. So after we compile all of these laws every year, we then take those 15 different categories for each state, and we compare them. We compare the states to each other, and we rank them against each other. So this can actually get pretty competitive in a good way. It's a good impetus for change at the legislative level, and we've actually seen a lot of local lawmakers who will cite our rankings as a reason that they want to improve their animal protection laws in their state. So, if the next state over has a better law than they do on animal abuse, stronger penalties, and so forth. Sometimes folks don't want to be seen as being too easy on animal abusers. And these are the categories that I mentioned. Again, basic prohibitions on abuse and neglect, penalties for those crimes, reporting requirements for veterinarians and other agencies, components of sentencing like mental health evaluations, and possession bans on animal ownership. So animal law has really changed a lot in the US just in the past couple decades. In 1992, only 7 states had felony laws on the books for animal cruelty. And in the US, a felony carries a stronger penalty than a misdemeanor. A felony usually implies 1 year or more of prison time and a larger fine than a misdemeanor. So as of 2014, actually, all 50 states in the United States have felony penalties available for animal cruelty. Now, does this mean that any act of animal cruelty, any abuse or neglect, is automatically a felony? No, that's really reserved for the most egregious animal cruelty offenses, like torture, extreme neglect that results in the death of the animal, and so forth. Many states require that aggravating factors be present, such as the offender has prior convictions for animal abuse, a minor was present, multiple animals were involved, and so forth. So a prosecutor also has to look at how is the term animal defined in the cruelty law. Every state defines animal a bit differently. So does animal mean companion animals only? Are horses companion animals, or are they livestock animals? What about fish, reptiles, mice? Are vermin or pests excluded? Can the same animal be excluded from the law depending on the context? It can be a pest, perhaps if it's found outside the home, but it could be that same exact animal could be considered a companion if it's kept as a pet. In the state of New Mexico, for example, animal does not include insects or reptiles. But in California, the definition of animal includes every dumb creature. So important to look at your statute. How are terms like cruelty, abuse, or neglect defined? Criminal laws here in the US are broken into 2 major components. So the mental state of the offender, did they act knowingly, recklessly, what was their mental state, and then the act itself, which we also call the actus reus. So this is California's cruelty law. The mental state here is in red, and I've put the act in green. So here the offender must act with intent, which is really the hardest mental state to prove, in addition to proving that he or she actually committed the act of maiming, mutilating, torturing, and so forth. Animal neglect is prescribed here as depriving an animal of sustenance, drink, or shelter. And notice that some of this language really sounds a bit antiquated. We don't use terms like overdrive or sustenance really anymore in our rhetoric when referring to animal issues. But this language originated back in the 1800s and has not been changed since. And that can really present a lot of problems to prosecutors who are trying to charge abuse or neglect based on these terms. And defendants have even raised challenges to the laws themselves. Like in this recent case called People versus Spiegel in California. This defendant owned 200 poodles, 1 cat, and 3 horses. And at the time of the seizure, the dogs suffered from severe matting, fleas, ear and eye problems, parasites, rotted teeth. They're really severely malnourished. The defendant was convicted of 8 felony counts as to the dogs and a misdemeanor as to a horse found on the property. So this defendant appealed that decision and argued that the California animal cruelty law was too vague. Specifically, the terms depriving an animal of necessary sustenance, drink or shelter, needless suffering, proper food and drink, and so forth. The defendant said that the statute was so general that a person of common intelligence had to guess what conduct was lawful. Court didn't buy it. Court says, no, it's impossible for the legislature to really list and anticipate every possible unlawful act, and that here it was very clear that the defendant should have known that their conduct was not allowable. So this statute in California certainly has much room for improvement, but the legislature has yet to change that specific language. So in a hoarding case like Spiegel, prosecutors often don't know how many charges to file. What do we do when we have dozens or even hundreds of animal victims in these cases? This can really be a very cumbersome process for prosecutors and confusing for jurors who are deliberating about the charges. So when we at ALDF conduct trainings, we always encourage one charge for each individual animal involved, and some states actually require this by law now. In some states, they say, you know, there are as many separate punishable offenses as there are victims. And why does this matter? In many states, this matters for purposes of penalties, for future ownership bans on animals, for punishment of future offenses. And as a policy matter, should an offender receive the same number of charges, the same punishment for abusing one dog as they do for 100 dogs? We believe no. So here's an example of itemized charges connected to each individual animal in a case. It's very important to stay organized about which animals suffered from which injuries. So you'll see, for example, count 47, belonged here to rabbit 11-560. This will help not only the prosecutor stay organized, but also the jurors to be able to go back, connect photos to a specific numbered animal. Legislative trends. Before we get back into some other trial issues, I want to talk about other legislation related to cruelty charges that are helping to protect animals. So protective orders in the United States can now include animal victims. By way of background, the link between violence to human victims and against animals is now really indisputable. We have the numbers to back it up. It's now extremely well documented. Abusers of animals are 5 times more likely to go on to harm animals in the future. And there was a time when animal cruelty was considered to be unrelated to human crime and even inferior in terms of resource allocation, but we're really seeing a change in that dynamic with law enforcement, with prosecutors, with other agencies who are now better understanding this link. So lawmakers in the United States have taken the very important step of including pets and other animals in domestic violence protective orders. So too often we've seen that human victims of domestic violence are afraid of leaving their abusers out of fear that their animals will be in danger if they leave. Because abusers will often use pets as a pawn and threaten to harm that animal or animals if the human victim leaves. So now these laws are great because they allow for pets to be included in orders protecting human victims. And more than half of all US states now have these laws on the books. This is an example from Oregon where I am. The court must order certain relief to protect the safety of animals if the petitioner shows that there's a credible threat of imminent danger to that person or child. Another great trend in animal legislation in the US is bans on animal ownership after conviction. And these possession bans are ordered as part of sentencing after an animal abuser has been convicted. And most states now allow for a judge to order these bans, and some even require, it's mandatory, that these prohibitions are put on animal ownership for a certain period of time. So that might be 5 years, 15 years, sometimes at the judge's discretion, depending on the severity of the offense. It's really important in cases like hoarding, especially where the recidivism rate is so high for these offenders, to not allow them to have animals in the future. Another trend that we're seeing legislatively is laws that allow veterinarians to report animal cruelty. Now, this may seem really commonsensical. Why would we actually need a law that allows vets to report animal abuse or neglect to law enforcement? Well, veterinarians are bound by ethics rules about client confidentiality and the client being the human owner. But vets are also often the only people besides the abuser who actually sees the abused or neglected animal outside of the home and can actually do anything about it. So the majority of US states now grant vets immunity, legal immunity for reporting animal cruelty. And some states even require that vets report suspected abuse or neglect. And this means that more and more animals have a better chance of being rescued from these situations where they would otherwise just be hidden away from all other human contact. This is an example of a veterinary reporting law that we have here in Oregon, and you can see that the legislature actually made the finding that there is a link between animal abuse and human abuse, and that's one of the reasons that we need to allow veterinarians to report cruelty. Dogs in hot cars, this is another issue that's really sweeping the US right now, and people are really fired up about it. Many people don't understand that leaving a dog in a car on a sunny day, even when it doesn't seem at all hot outside, poses a very real danger to that animal because of the rate at which the car can heat up from the inside, even with a cracked window. So more and more states are passing laws that explicitly criminalize leaving an animal in a hot car, and even empowering not only law enforcement, but ordinary citizens to break into a car without any legal liability to rescue that animal. Costs of care, again, tying into our pre-conviction forfeiture conversation, most states now require a defendant to pay for all of those exorbitant costs of care that come with lawfully seizing an animal from the time of seizure all the way through trial, again, because those costs can really add up very quickly. The policy is that the defendant still legally owns the animal, even though the defendant is not in the legal possession. The animal is not in the legal possession of the defendant. Defendant still owns the animal and therefore is legally obligated to pay for that care. And finally, ag-gag laws. These laws criminalize whistleblower action, those who expose hidden practices of the animal industry, like the food industry or puppy mills. And we've had a lot of success actually in the US challenging some of these laws and defeating some bills, some ag-gag bills that never came to pass. So ALDF's litigation team has been very active along with a coalition of other groups, and they recently won a case in the state of Idaho, and that court found that that ag-gag law was unconstitutional because it impeded free speech principles. And you can visit our website, again, aldf.org, for more information about our ag-gag lawsuits. So back to our animal cruelty case. So the animals have been seized, prosecutor filed charges, defendant won't plea, so we're going to trial. Experts are really very crucial in an animal cruelty case. They're so important because they educate the jury about the animal and about the scene. They can describe the disease, the injury, the pain and suffering of the animal better than a prosecutor can, better than a layperson. And they can delineate between human and non-human causes of injury and between accidental and intentional injury as well. They can also describe in neglect cases what could and should have been done, and they lay the scientific basis for causation. And so again, they can really interpret this evidence in a way that a layperson on the stand could not. So some of the most common experts that we use in animal cruelty cases, animal control officers or other law enforcement that are specially trained in dealing with animals, and of course, veterinarians. Other potential experts in animal cruelty cases, depending on the type of animal that you're dealing with, farriers and groomers for horse cases, of course, wildlife, exotics experts, and so forth. I'm just going to skip a couple of these slides here for the interest of time. And we at ALDF in the criminal justice program will not only help to prep experts for cruelty cases, but we also have grant money to help fund these experts when prosecutors' offices cannot otherwise afford it. Knowing your community as a prosecutor is really important, from picking your jury all the way through trial. Issues are really not treated the same in every different area. Even if there is a law on the books, you as a prosecutor need to decide, knowing what kind of jury pool you're working with, is it worth charging this case? Is it likely that they will convict? Dogs riding in pickup trucks is kind of a hot button issue. This maybe can be prosecuted in a more urban setting, but it's less likely in a more rural county where dogs are used on farms, for example. It's important to know that a lot of people still have a bias against animal control officers. They might not understand the extent of their work and might still perceive them as dog catchers and not really knowledgeable about animals in all the ways that they are. Species bias, going back to our definition of animal. There it goes. Even if a certain animal is technically included under a statute, how will a jury respond? Breed bias, again, even if the law doesn't ban a person from having certain breeds, what is the public's perception and how will that change the outcome of a case? And finally, just the perception that livestock, again, even if they're included in the definition of animal, cruelty toward livestock, some people just think that these types of animals just simply can't be victims and a person should not be convicted of a crime against these type of animals. So Jackson, I want to check in with you. I see that we're about 5 minutes till, and I want to leave some time for questions. Would you prefer that I wrap up now?
Probably, Lora, yeah. It's 5 to the hour, so there might be talking shortly. So we might just have a couple of questions. That's all right.
I would love to take some questions, yes, and I'll be advancing just to my last slide as that happens.
Yeah, great. Does anyone have any questions? Can I just ask before anyone else? Can you just give a quick overview of how you got to working where you are? So a lot of the students here have studied animal law and would love a career working in the field. Can you just give a quick background as to how you got to working full time in this area? I know it's very different in terms of the jurisdiction, but just a brief overview.
And I will start by saying that I got very lucky. So I was hired by our former director now, but the director of our criminal justice program, who was a prosecutor for about 20 years. He was an elected district attorney in Oregon, and he was a prosecutor for many years, and then ended up wanting to specialize in this certain type of law. So I had another career in marketing and book publishing, and just had really always been a vegetarian for many years, and wanted to get more involved in animal activism, but wanted to do it in a way that I thought would be, for me, most effective. So I ended up going to law school at Lewis and Clark Law School in Oregon, where the Center for Animal Law Studies is housed, which is really, I'm biased, of course, but here in the U.S., the Center for Animal Law Studies has a very special relationship with the Animal Legal Defense Fund, and because of that, our program at Lewis and Clark is really top-notch. They're very connected with all of the experts throughout the U.S. that have been doing this type of law for many years. This is a very long answer to your question, but I ended up going to law school at Lewis and Clark, ended up just doing a lot of networking and spending a lot of time, a lot of the limited free time that I had in law school, just trying to meet as many people as possible. Ended up clerking throughout law school for the Animal Legal Defense Fund, and then was hired on out of law school. I know many people that have many different paths, especially in the criminal justice world. Many folks will work as prosecutors first for years, and then go into a nonprofit like ALDF, bringing that specialty with them. But I was fortunate enough to get hired right out of law school, and that's where I am today.
Wonderful. Does anyone have any quick questions?
I was wondering how many successful in the state.
Did you hear that, Laura?
I did not. I heard a little bit of the first part. Could you repeat it?
It's roughly how many successful prosecutions would you have in your state each year in Oregon?
That's a very good question. So we're not, I'll answer that in two parts. First, we really don't have very specific documentation of how many cases are charged and then how many cases end up with a conviction. I can segue to my next slide here. The good news is that the FBI, the Federal Bureau of Investigations throughout the U.S., will now be tracking animal crimes specifically. Previously, animal crimes had been kind of thrown into this miscellaneous category with many different unrelated crimes, but now the FBI is keeping kind of closer watch on animal crimes specifically, and we'll be able to have more solid numbers on that kind of data. I can tell you that in the criminal justice program, and again, we assist with cases throughout the country, we work on about 120 cases each year in some form.
Right. And sorry. Yep. Yeah.
Laura, thank you. When you do get a conviction, I'm interested in the sentencing outcomes. And I also wonder whether you have continuing judicial education in either Oregon or other states, because sentencing is a problem throughout at least the common law world.
Yes, absolutely. So we will work with prosecutors not only through trial, but also through the sentencing phase. And education of judges is very much an uphill battle. The good news is that more and more judges, as I hate to say it this way, but as judges are getting older and being replaced by some younger folks who have some kind of awareness of these animal issues, that is helping us with sentencing. In addition, we have been able to participate in trainings. ALDF has been able to participate in trainings for judges specifically speaking to them about animal cases. And in one specific training that I'm thinking of from last year, we actually had a very direct impact on one judge who was actually sitting on an animal cruelty case, didn't really understand the importance of the issues, and then after this training ended up going back the next week, just kind of had a complete change of heart, and understood the importance of putting this particular individual behind bars. So the good news is that it's absolutely an uphill battle, but we are seeing change at the judicial level.